Public Health Code Excerpts. Act 368 of 1978. An act to protect and promote the public health, to codify, revise, consolidate, classify, and to add to the laws relating to public health, to provide for the prevention and control of diseases and disabilities, to provide for the classification, administration, regulation, financing, and maintenance of personal, environmental, and other health services and activities, to create or continue and prescribe the powers and duties of department boards, commissions, councils, committees, task forces, and other agencies, to prescribe the powers and duties of governmental entities and officials, to regulate occupations, facilities, and agencies affecting the public health, to regulate health maintenance, organizations, and certain third-party administrators and insurers, to provide for the imposition of a regulatory fee, to promote the efficient and economical delivery of healthcare services, to provide for the appropriate utilization of healthcare facilities and services, and to provide for the closures of hospitals or consolidation of hospitals or services, to provide for the collection and use of data and information, to provide for the transfer of property, to provide certain immunity from liability, to regulate and prohibit the sale and offering for sale of drug paraphernalia under certain circumstances, to provide for penalties and remedies, to provide for sanctions for violations of this act and local ordinances, to repeal certain acts and parts of acts, and to repeal certain parts of this act and to repeal certain parts of this act on specific dates. The people of the state of Michigan enact Part 127, Water Supply and Sewer Systems. Section 127.01, Part 1, as used in Section 127.01 to 127.15. A person means a person as defined in Section 1106 or a governmental entity. B. Pump means a mechanical equipment or device used to remove water from a well. C. Pump installer means a person who is qualified to engage in the installation, removal, alteration, or repair of water well pumping equipment in connection with a water well. D. Well means an opening in the surface of the earth for the purpose of removing fresh water, or a test well, recharge well, waste disposal well, or a well used temporarily for dewatering purposes during construction. Well drilling contractor means a person qualified to engage in well construction, well alteration, or well repair and pump installation, who supervises the construction of water wells and the installation of pumps, and who owns, rents, or leases the equipment used in the construction of water wells. In addition, Article 1 contains general definitions and principles of construction applicable to all articles in this code. Applicability of sections 333.127.01 to 333.127.15. Section 127.03, 1. Sections 127.01 to 127.15 shall not apply to A. A well, pump, or other equipment used temporarily for dewatering purposes during construction when the well is not more than 2 inches in diameter and not more than 25 feet in total depth below the natural ground surface, or is used in the relief of artesian pressure at hydroelectric projects, or is used with the drilling of oil or gas wells. B. A brine, test, storage, or disposal well regulated pursuant to Act No. 315 of Public Acts of 1969, being Sections 319.211 to 319.236 of the Michigan Compiled Laws. 2. Sections 127.01 to 127.15 shall not prevent a person from constructing a well or installing a pump on property owned or leased by the person which is intended for use only in a single-family house, which is that person's permanent residence, or intended for use only for farming purposes on that person's farm, and where the waters to be produced are not intended for use by the public or in any residence other than his or her own. The person shall submit the drilling record required by Section 127.07 and comply with the rules and construction code promulgated under Section 127.14. 3. Sections 127.01 to 127.15 shall not restrict a master plumber license under Act Number 266 of the Public Acts of 1929, as amended, being Sections 338 to 901 to 338.917 of the Michigan compiled laws from engaging in the licensee's legally recognized trade. A licensed master plumber may perform the work of a pump installer prescribed in Sections 127.01 to 127.15, or Rules and Construction Code promulgated under Section 127.14 without a certificate of registration as a pump installer. 1 second, I'm going to take a bite of ice cream. Okay. 333.127.04. Certificate of registration as well drilling contractor, pump installer, water well drilling contractor, or dewatering well pump installer. Application, fees, exemption. Section 127.04.1. Before engaging in the business of well drilling or pump installing, a person shall obtain a certificate of registration annually as a well drilling contractor or pump installer using an application prepared by the department. 2. Before engaging in the business of constructing dewatering wells or installing dewatering well pumps, a person shall obtain a certificate of registration annually as a water well drilling contractor limited to the construction of dewatering wells or as a dewatering well pump installer using an application prepared by the department. 3. The applicant shall pay a registration fee with the application. The initial registration fee and the annual renewal registration fee for a well drilling contractor is $40 and for a pump installer is $25. A well drilling contractor shall pay an additional annual fee of $10 for each additional drilling machine. A registered well drilling contractor may do any of the work of a pump installer without payment of the fee for a pump installer. 4. A county, city, village, township, or other governmental unit engaged in well drilling or pump installing shall be registered under Sections 127.01 to 127.15, but shall be exempt from paying the registration fees if the drilling or installing is done by regular employees of and with equipment owned by the governmental unit and the work is on wells or pumps intended for use by the governmental unit. 333.127.05. Certificate of registration, issuance, non-transferable, expiration, renewal, examination, eligibility, and reciprocity. Section 127.05. 1. The department shall issue certificates of registration to well drilling contractors and pump installers who meet the requirements of Sections 127.01 to 127.15. 2. A certificate of registration is not transferable and expires on April 30th of each year. After July 1st of each year, a certificate of registration may be renewed only upon application for renewal and payment of a fee of 50% of the basic registration fee in addition to the regular registration fee. 3. A new applicant for a certificate of registration shall be examined in accordance with the Rules and Construction Code promulgated under Section 127.14. The advisory board created by Section 127.11 shall determine and advise the department as to the eligibility of a well drilling contractor or pump installer for registration. A well drilling contractor or pump installer, which is a firm, partnership, or corporation shall designate at least one partner, officer, or responsible full-time employee to take the examination on its behalf. 4. The department, upon application and payment of the prescribed fees, may issue a certificate of registration as a well drilling contractor or a pump installer to a person who holds a similar certificate of registration in another state or a foreign country, if the requirements for the registration of a well drilling contractor and pump installer under which the certificate of registration was issued do not conflict with this part, are of a standard not lower than that specified by the rules and construction code promulgated under section 127.14, and if equal reciprocal privileges are granted to a registrant of this state. 333.127.06 Numbers, seal, and words to be placed on a well drilling machine. Section 127.06 A well drilling contractor shall place the registration number, including the county code number for the business location, in figures not less than 2 inches high in a conspicuous location on both sides of the contractor's well drilling machine. A seal furnished by the department designating the year the certificate of registration was issued or renewed and the words Michigan Registered Water Well Drilling Contractor shall be affixed directly adjacent to the registration number. 333.127.07 Record required, contents, copies, forms, sufficiency of record for drive point well. Section 127.07 Not later than 60 days after the completion of a well drilling contractor shall provide the owner with a copy and the department or local health department with 2 copies of a record indicating the well owner's name, location of the well depth, geologic materials and thicknesses of materials penetrated, amount of casing, static water levels, and any other information which may be required by the rules and construction code promulgated under section 127.14. The department or local health department shall send 1 copy of the record to the director of the Department of Natural Resources not later than 30 days after its receipt from the well drilling contractor. Standard forms for the record shall be provided by the department, or the contractor's forms may be used if approved by the department. A record for a drive point well where no earth materials are removed from the well bore is sufficient if the owner's name, well location, depth, casing, static water level, and screen data are stated. 333.127.08 Entering and inspecting installation. Section 127.08 The department or local health department may enter and inspect, at reasonable hours, an installation on public or private property for the development or abandonment of groundwater supplies. Another ice cream break. 333.127.09 Inspection of violation order, notice of suspension of certificate of registration, petition for hearing, revocation of certificate of registration. Section 127.09 1. When the department or local health department determines that there are reasonable grounds to believe that there has been a violation of sections 127.01 to 127.15 or a rule or the construction code promulgated under section 127.14, the department or the local health department shall investigate the violation. If the department or local health department establishes that a violation has been committed, the department or the local health department shall order the responsible person to make the proper corrections. 2. When the department finds that the holder of a certificate of registration has engaged in a practice in violation of sections 127.01 to 127.15, or a rule, construction code, or order issued pursuant to those sections, the department may give written notice to the holder of the certificate of registration that the certificate of registration is suspended. A person who receives notice from the department that his or her certificate of registration is suspended, upon request, shall be granted a hearing before the department or an authorized representative of the department. If a petition for a hearing is not filed within 30 days after the day on which the certificate of registration was suspended, the certificate of registration is automatically revoked. 333.127.11 Advisory Board, Creation, Appointment and Qualifications of Members. Section 127.11 An advisory board of 9 members is created in the department composed of the following: 5 members who are residents of this state registered under sections 127.01 to 127.15, at least 4 of whom are well drilling contractors, and who shall be appointed by the governor with the advice and consent of the Senate. An employee of the Bureau of Environmental and Occupational Health of the department, and a representative of a local health department, each to be appointed by the director. An employee of the Geological Survey section of the Department of Natural Resources, appointed by the director of the Department of Natural Resources, and an employee of the Water Resources Commission, appointed by the Executive Secretary of the Water Resources Commission. Of 4 well drilling contractors, 1 shall be from each of 4 geographic regions. Region 1, the Upper Peninsula. Region 2, the part of the Lower Peninsula bordered on the south by Oceania, Newego, Mecosta, Isabella, Midland, and Bay counties, and the area north of those counties. Region 3, the area bordered on the north and west by Huron, Tuscola, Saginaw, Shiawassee, Livingston, Washtenaw, and Lenawee counties, and the area south and east of those counties. Region 4, the area bordered on the east and north by Hillsdale, Jackson, Ingham, Clinton, Gratiot, Montcalm, Kent, and Muskegon counties, and the area south and west of those counties. 333.127.12 Advisory Board, Terms of Members, Vacancies. Section 127.12 Each member of the Advisory Board shall be appointed for a 3-year term. The terms of the 5 members registered under sections 127.01 to 127.15 shall alternate so that not more than 2 are appointed each year, except that of the first appointees. 1 shall be appointed for 1 year, and 2 shall be appointed for 2 and 3 years. The terms of the members representing the Department of Natural Resources, the Water Resources Commission, and the local health department shall alternate so that only 1 is appointed each year, except that of the first appointees. 1 member shall be appointed for 1 year, 1 for 2 years, and 1 for 3 years. Vacancies shall be filled by appointment for the balance of the unexpired terms by the respective officials designated in section 127.11. 333.127.13 Advisory Board, Election of Chairperson, Secretary, Number of Meetings, Quorum, Conducting Business at Public Meeting, Notice of Public Meeting, Compensation and Expenses. Section 127.13 1. The members of the Advisory Board, as soon as appointed, shall organize and elect from their number a chairperson. Thereafter, annually, when new members are appointed to the board, a chairperson shall be elected at the next board meeting. The member from the department shall be the secretary of the board. The board shall hold not less than 1 meeting each year for the purpose of examining candidates for registration. Additional meetings may be called by the chairperson or director as may be reasonably necessary to carry out sections 127.01 to 127.15. 5 members shall constitute a quorum. The business which the advisory board may perform shall be conducted at a public meeting of the advisory board held in compliance with Act Number 267 of the Public Health Acts of 1976, as amended, being sections 15.261 to 15.275 of the Michigan compiled laws. Public notice of the time, date, and place of the meeting shall be given in the manner required by Act Number 267 of the Public Acts of 1976, as amended. 3. The per diem compensation of the members of the advisory board registered under sections 127.01 to 127.15 shall be established annually by the legislature. Expenses shall be reimbursed pursuant to section 121.6. 333.127.14 Rules and Construction Code. Section 127.14. The department, with the advice of the advisory board, shall promulgate rules and a construction code reasonably necessary to implement sections 127.01 to 127.15. The rules and construction code shall include provisions for qualifications and the examination of well drilling contractors and pump installers, standards for the construction and installations of developments of groundwater supplies, dewatering wells, abandonment of wells, and dewatering wells, and for the administration of sections 127.01 to 127.15. 333.127.15 Violation as misdemeanor. Penalties. Prosecution. Section 127.15 1. Except as provided in subsection 2, a person who violates sections 127.01 to 127.14, a rule or the construction code promulgated under sections 127.14, or an order issued by the department or local health department under sections 127.01 to 127.14, is guilty of a misdemeanor. 2. A member of the advisory board who intentionally violates sections 127.13.2 shall be subject to the penalties prescribed in Act Number 267 of the Public Acts of 1976, as amended. 3. The Attorney General or local prosecuting attorney shall be responsible for prosecuting a person who violates sections 127.01 to 127.15.